Welcome, everyone. Thanks for calling in. Happy lunch hour to our friends on the West Coast. Thank you so much for joining us for our first civil justice seminar of the year, Criminal versus Civil Cases, Understanding the Crucial Interplay for Sexual Abuse and Assault Victims. Before we begin, just a couple of housekeeping items. First, we are in Zoom webinar mode, so your mic is muted automatically and you will not be able to be on video. We are going to go ahead and leave the chat box open for everyone so that you can talk amongst yourselves. As far as Zoom, we will be toggling back and forth between screens. So please go ahead and set your view preferences to speaker mode now. You can do that by hovering over the top right portion of your screen and selecting speaker view. We will be taking questions today, but there are so many folks registered and calling in that we're going to ask that you use the Q&A function only to pose those questions and that you don't use the chat box. We won't be monitoring the chat box as closely, so the best way to get your question is to, again, make sure you use the Q&A function, which you can find by hovering at the bottom of your Zoom screen. I'll likely hold the questions to the end, but if they're really good and timely ones, or if you're asking for repetition, I'll go ahead and jump in and ask them right away. There are no CEUs today. However, you will get an email confirming your registration. We are also recording today's session, and that will be emailed to all of the registrants, and it will be available on our NCVC YouTube page. With that, I'd like to welcome our speakers today. First, Dave Ring from Taylor & Ring in Los Angeles. For more than 20 years, Dave has represented victims of sexual abuse, sexual harassment, assault, molestation, and sexual misconduct in cases against a variety of employers and entities, including schools, churches, and youth organizations, providing aggressive but compassionate representation for children who've been sexually abused and women who have been sexually harassed and assaulted. We also welcome Matt Murphy. Matt has over 21 years of experience fighting on behalf of sexual assault victims and their families. Matt was sworn in as Deputy District Attorney in Orange County in 1993, and he spent several years as the Senior Deputy District Attorney, successfully trying over 200 criminal cases to verdict, including well over 100 jury trials. Matt now has a private practice fighting for survivors of sexual abuse in civil court. Dave and Matt, thanks for joining us. I'm going to turn this over to you.
Thank you so much, Renee. Good afternoon, everybody. It's great to be here, and it's great to be here with Matt Murphy as well. So you're going to hear from both of us. We're going to go back and forth. We have a PowerPoint, so I'll kind of put some slides up along the way. But let me start by saying this. You know, what we're trying to accomplish here today is you know, I assume that many of you out there are victim advocates. You help victims. You give them advice, and you may be their very first person that they come to reveal that they've been abused. It could be a child. It could be an adult who was, you know, sexually assaulted as an adult. It could be an adult who was sexually abused back in their childhood. But you, as the first point of contact, incredibly important. And so in my practice, at least, I hear a lot of confusion when I talk to victims who come to me, because they're not really clear on the criminal versus the civil process. And I kind of take it for granted sometimes that I think that they are. And I realize there's a lot of confusion out there amongst a lot of folks because there is a lot of crossover. And so Matt's goal and my goal here today is to kind of walk you through it from our different perspectives. And I'll introduce Matt, but just so you know, Renee touched on it already. I've been a plaintiff's lawyer representing victims for a long, long time. If you recognize Matt, it's because he's on TV all the time. He's a former prosecutor, did this really, really high profile cases here in California. And now he's on 2020 and ABC News as a legal commentator. And he's also representing victims like I am as well. So let me get Matt in there. And then as when he's done, we'll go to our first slide on our first issue.
Yeah, well, thanks for having us. One of the interesting things about what Dave just said about clients being confused is that one of the things that's fascinating from an attorney perspective on this is how many lawyers actually don't know how this works. And the interplay between criminal and civil is one of those types of cases when you're talking about sexual assault where it begins applying almost immediately. Like once somebody is arrested or there's a criminal investigation, lot of times people will go out and get a civil attorney. And Dave and I actually met each other on a case. It's scary to think how long ago this was, but it was about, what, Dave, over 20 years ago. And we've been friends ever since. And now the awesome thing is we're working together on some of these cases, which is fantastic. But the interplay and understanding how the civil case can impact the criminal and vice versa is something a lot of lawyers don't even know.
So let's do this. I think it's helpful sometimes if you want both Matt and my email address, it's on there. We both urge you to follow us on Instagram. That's on there. We can show you that at the end as well. There's Matt's information also. Give you a second. So look, we get to our first issue as a victim advocate, or just for anyone out there. A victim comes to you, again, child, could be adult. Who do you send them to? Do you send them to law enforcement, to a civil lawyer? Do you send them to both? Do you give them names for both? And what advice do you give them along the way? I'm going to let Matt run with this one first.
Yeah, so essentially the first thing, of course, is always to make sure that that local law enforcement is notified of this and that local law enforcement is apprised. And one of the critical things to remember in something like this is that if they go to a civil attorney first, Dave Ring is the man, like Dave, and there are lawyers out there. I don't think literally anybody in the country knows this as well as Dave does, and I'm not blowing smoke, but there are a lot of attorneys like that might specialize in other areas that don't understand the critical impact. And what am I talking about, when I talk about critical impact? For example, if you get some schlocky PI guy that runs off and files a civil suit before the DA has had an opportunity to review the case for charges, or even sometimes when they believe there's enough evidence for a case and they're proceeding with the case, and then the family, without knowing any better, goes and hires a civil attorney. If they start conducting depositions, what are depositions of? They're of the same witnesses that are going to be testifying in a criminal case, and that can be hugely problematic depending on the circumstances of the case. So just having a few of these nuts and bolts, understanding the way it works might really help you guys, do the critical, very important job that you have, and that's ushering victims through this maze of the criminal and civil justice system.
Now, many of you are probably, I assume, you're mandated reporters of child abuse. I think every state has that type of law where if you're kind of a child care, someone who interacts with children on a regular basis, all sorts of professions, you're required, and someone comes to you and says, I was abused, and you have a reasonable suspicion that they were, you have to report that. So that takes the decision out of your hands. But still, the follow-up to that is, okay, do I tell this victim to now they go report it to the police as well, or do they go talk to a lawyer? And I think you always tell them they should go to the police and report it. But I also think certain times it's important to tell them, look, you should consult a civil lawyer as well. And we're going to get to it in this seminar as to there's some really important reasons why they should have, a good civil lawyer guiding them through the criminal process. And if it works out well, it can dovetail. But I also find out more and more now that I get a lot of phone calls from victims and I'm their first contact. And maybe that's because it's easy for them to find lawyers like me on the internet, and they can reach out to me in a phone call. Whereas I don't know if it's that easy for them to do that with law enforcement, and certainly not with a district attorney. And they don't know who to call, or they get put on hold for a long time. And so they see lawyers on the internet who handle these cases, and okay, I'm going to call them. And we get a lot of calls. And so I always try to make it a point to tell them, look, you have got to go report this to the police, and let's see what they do. I think that's incredibly important. But you can see how both tracks of both criminal and civil like Matt said, can easily start at the same time, and that's where it can get confusing. Let me,
Yeah.
let
Let me
me,
expand on that just first. I'm sorry, Dave. Go
yeah,
ahead.
no, I'm going to go to Matt with, so the next step is, you know, Matt's playing the prosecutor today, the prosecutor's ideal interplay. What's the perfect situation that Matt would like to see as a prosecutor if there is a potential civil case? And let me just say this too, when I talk about a civil case, look, there's always going to be a civil case against the perpetrator, but that's really not what we're focused on. We're talking about a case where, whether it's a school district or some other entity who employed the perpetrator, really allowed this to happen, and the person has a civil lawsuit against that entity. That's what we're talking about. So let me go to Matt on this issue.
So there is the first thing that you hope for is that you're going to have somebody that's going to work with the prosecution, and there's a term that's a little complicated, but the idea is really not, and that's called collateral estoppel. Okay, so in a criminal case, the burden of proof is beyond a reasonable doubt. So that is the burden of proof, and that's the highest burden of proof we have in the law. But if it's based on the same facts, it means that in the civil case, essentially they automatically win as long as the criminal case is successful. So once you prove a case beyond a reasonable doubt in the criminal case, what that means is that the burden of proof in a civil case is what's called by a preponderance, or by 51%. So what that means is it's in everybody's best interest, if the DA is actually pursuing the case, to make sure that they're successful in that, because then the only question for civil litigation becomes damages. So an example of that way back when is Mike Tyson. Remember, Mike Tyson was prosecuted for rape. Once he was convicted of rape, the only question for that young woman and her attorneys was how much were the damages worth. So there really is a kind of a symbiotic relationship legally. So as a prosecutor, what you're hoping, and whenever I would sit down with my families, I did sexual assault and homicide cases are oftentimes just an overlap. A lot of them are sexual assault cases, tragically. But the first thing you do is you sit down with the family and you kind of walk them through the entire process. And part of that is letting them know that if they're going to pursue their legal remedies, just to be aware, if they're going to do it in civil, to please hire somebody that knows what they're doing, so that we can work together to make sure that they're successful in the civil case and that we're successful in the criminal case. And that's for the prosecution standpoint, that's what you want. And it is an absolute nightmare when you find out that the family went against your advice and hired a lawyer without talking to you, or hired a lawyer that we're allowed to give 3 names is what we'd have to do. So Dave Ring was obviously the first name on my list every time over those years. And, but sometimes the family has a friend who watched a commercial at 3 o'clock in the morning and saw an ambulance chases RS or whatever. And all of a sudden, as a prosecutor, you're dealing with somebody that doesn't know what they're doing, who's running off doing depositions. Sometimes they even have press conferences. And it's maddening, because it undermines both. It undermines the criminal and the civil. And look, one of the things I loved about working with guys like Dave, and really guys like, that essentially is Dave and his partner, and that's about it. Because I knew that when they were in such good hands with Dave, that not only was I going to get criminal justice and get the guy hopefully a lengthy prison sentence, but that the family would be compensated in some way, because they had such good plaintiffs lawyers. So that's a win-win for everybody. Bad guy goes to jail, family actually gets compensated for what happened to them. That's the home run that we're all looking for.
Hey, Matt, one question came up just of clarification.
Yep.
Somebody said collateral what? They missed the second word you said. So what was that collateral? And can you fully explain that concept?
Oh, it's called collateral estoppel. Yeah, and this is about 3 months worth of law school to understand it, but and it's Latin, okay? But collateral estoppel means it is a different case. Estoppel means they are stopped or just stopped. So what does that mean? That means that you could have, and this is something that Dave and I dealt with on the Abianca case we're going to talk about later. You can have a really feisty civil defense lawyer who really wants to relitigate the issues, but using the Mike Tyson thing as an example, that went to trial. The prosecutor won. The defense lawyer, I don't know what kind of job they did, but Mike Tyson was convicted of rape. So what that means is on the civil side, they were stopped. They were stopped from arguing whether or not he was raped, if that makes sense, because the burden of proof for the rape was much higher than just a preponderance, which is what it is in the civil case. So criminal is beyond a reasonable doubt. We all know that's the highest standard of proof. Civil, it's just 51% basically. Is it truth to a preponderance? So if you've already proven it to the highest standard, and it's the same facts, and it's on the civil case, was she raped by Mike Tyson? It's already been proven to a higher standard. So that's what it means. Collateral means it's on the side, and a stopped means they can't argue those issues anymore. So then it goes directly into damages. What's it worth to take a young woman's dignity during the course of a rape? And I don't remember how much she got, but it was a lot. And it's probably more than Mike Tyson has today. So.
So look, so Matt told you about his ideal setup from the prosecutor's point of view. And hey, look, I've seen it happen where lawyers, plaintiff lawyers or victims lawyers get involved, and they can really, really mess up the criminal case. And I think everyone's priority has to be the criminal case and putting the bad guy in jail or in prison. And if that's not everyone's number one priority to begin with, on my side of things, that's going to be a big problem. And you're going to see lawyers out there making mistakes that really upset law enforcement and really upset prosecutors. But from my perspective too, look, there are times, a lot of times, where the victim comes to me first. They haven't gone to the police, and I'm not just going to tell that victim, oh, come back in 2 years when the criminal case is over. No way. I mean, I want to represent that person. And so here's how I guide myself when I'm doing that. And that's what we're trying to get across, is that the goal is to find lawyers, or at least to inform victims, hey, tell your civil lawyer, this is how it's got to work. I always stay out of the way of Matt Murphy's criminal case or anyone's criminal case, because I want to be the last person to interfere with that. So I stay behind the scenes, and I advise the victim, and I really stay behind the scenes. I mean, I do not file anything in court. I don't do anything publicly. I just stay behind the scenes, and it works out well, because then I can guide the victim, or whoever, if it's the victim's parents or whoever, I can tell them, hey, look, here's what's going on in the criminal case. And I can spend more time with them sometimes. Prosecutors are really, really, really busy, million cases on their plate. And I represent this victim. I can really walk them through the process of what's going on. My dream scenario is, okay, I send them to law enforcement, a report's made, an arrest is made, the DA charges the perpetrator with the crime, the criminal case goes quickly, there's a conviction, and then I get to come in and file my civil case against all the wrongdoers that allowed this to happen. Now, that's in a perfect world. That doesn't happen quite neatly like that all the time. And that's our next point is it can get messy. Usually it's a whole lot more complicated and messy than what Matt and I just spelled out for you. And so that's what we want you to understand too. Matt touched upon this a little bit, but Matt, tell us some of your nightmare scenarios that have happened to some of your cases because a civil lawyer has done something that's really upset the process.
Yeah, I'll give you a great example. And this is something that's a big media case. Some of you might have read about it, and I got to touch somewhat lightly because it's still pending. But there's a case out of Newport Beach involving a doctor and his girlfriend who are accused of sexually assaulting a bunch of women. And I represent 5 of those women right now in what's called MARSY'S law capacity, where I can be their lawyer, where I can essentially try to persuade the prosecutor or try to persuade the court, essentially to protect their rights. And what happened in that case is there were a whole group of women. There's 7 that are charged, and there's a series that were not charged. So we're talking well over a dozen women that came forward and basically reported that they've been raped by this couple. And one of them, of all these women, decided to hire a lawyer who filed a civil suit. And now what has happened is that opens up a process where the defense now has subpoena power. And imagine if you basically arm a defense lawyer with the power of subpoena, where they can bring in all the witnesses in the criminal case without a judge there, without the prosecutor there, and in many cases in this thing, without even the civil attorney, without even the plaintiff's lawyer there. So he launches this thing, and then it becomes this nightmare where they're interviewing all the witnesses for the criminal case. It's hugely problematic. And on the case that Dave and I did that we're going to talk about, it's a similar thing where we had a weak judge who Dave ran out of time on the statute, the way the law used to work back then. And so had to file the case, and we had a weak judge, and I'll leave her name out, who okayed the civil depositions of a bunch of 10-year-old boys. And it's like, and these guys just, I had Dave in there, but it's a nightmare for a prosecutor because now your witnesses are essentially being cross-examined, and it's not being done in front of a jury. And in that particular case, we'll get into more details on it, but they were asking a 10-year-old boy if he was gay. They were asking him if other things had happened. And it's from a prosecutor standpoint, they do that because they're attempting to undermine the criminal case, because that collateral estoppel that we were talking about. If they can make the criminal case unprosecutable, it means that they then get to defend it in civil court. And if they make it so bad and so messy that we cannot get a conviction as prosecutors, guess what? Then we don't get the conviction, and they can defend it in civil court. So it's like I love that scribbly line slide that Dave just put up, because that's such a perfect example of what we do. Everything is like, there's right and left turns. So procedurally, the key is get a good civil attorney. That's the simplest way I can put it. Dave knows how to work that. A lot of people they don't. Like in this case out of Newport, it's very difficult because these people, and my clients have nothing to do with that case, that don't even know the victim in that. They're trying to bring them in, and it's like, I don't want to get too much in the weeds on that, but I'm looking at that from the prosecutor standpoint, and it's a mess.
So now look, it's not all doom and gloom. I mean, there's some problems out there, but also, and there's plenty of competent lawyers out there who represent victims and know exactly what they're doing, and will definitely not interfere with the criminal case. And the key is for victim advocates, if you're going to share names with victims, is to kind of just go on the internet. You can tell who knows what they're talking about and who doesn't, who's represented victims and who doesn't. But look, it can really make a big difference if you have both the prosecution, and you also have a plaintiff attorney who knows what he or she is doing. It can help both cases. And I want to give another. Sometimes these war stories are the best way to convey points. So I have a case that's going on right now where these two criminal and civil really dovetailed perfectly to help out. And just real quickly on the facts, it's a really horrific case. All of these are, but it's in California, and is kind of up in a rural area of California. But you had a school bus driver who was driving special needs kids to school. He worked for the school district. And because it was in a somewhat rural area, there was often times where he would just have one special needs kids on the bus, just one kid for 20 minutes, taking them to school or to wherever. And this guy was a perpetrator. And so it turned out he was molesting this 9-year-old special needs girl on the bus. He would pull over along the route and he would molest her. It's horrific. And he ultimately, the girl, after a while, she complained about it, and the school district did not believe her. And then her parents, they went to the school district first, and they did not believe her. And the parents tried to get the school to do something, and the school just blew them off. And then they went to law enforcement, and law enforcement was phenomenal. They jumped on the case and they busted this guy, I swear, within about a week. And they found video footage from the bus that the school had in its possession the whole time. And they did all sorts of things, and they nailed this guy. And so so what happened was, then the girl's family came to me right around that same time. And I guided him. I'm like, look, just you gotta play this out and see where this goes. And one of the things that came out of the criminal case was, because we were working together, was the criminal case. It came out that this guy had a prior conviction for like peeping, like a peeping Tom conviction that completely barred him from being hired in the first place by this school. And the school, he'd applied, he'd lied about it. The school figured it out and said, we're not hiring you. And then 2 months later, hires him anyways, because he is a friend of someone. Unbelievable. And if we hadn't been working together, the prosecution and then me representing the girl, and we had these open lines of communication, that may never have come out, that the school knew all that. And so that's how, if it works right, these two cases can, and the guy got prosecuted, 25 years in prison, and the girl's going to be compensated for what she went through. So that's just an example of how this can work correctly. So let me go. One thing I want to talk about, I'm going to have Matt talk about it because it's confusing out there, is our next point is MARSY'S law. Okay. So there's a thing called MARSY'S law and MARSY'S law lawyers, which are different than prosecutors and different than plaintiff attorneys. I'll let Matt talk about this.
So MARSY'S law is also known as the Crime Victims Bill of Rights. And Marcy was a woman named Marcy Nicholas, whose brother invented Broadcom, which is basically broadband communication. So he's a billionaire here in Southern California. He sponsored this basically I'm sure most of you have heard of this before in the business, but it's every state hasn't adopted it yet, but most have. And essentially it's a constitutional amendment that gives victims a certain degree of rights, including the right to be free from harassment, to be treated with dignity and respect through the entire process. There's all of these really critical rights, and judges want to follow that. So what families have been doing more and more is they've been hiring attorneys to essentially shepherd them through the process. And by hired, for me, that means basically for free. So I do almost all my MARSY'S law work is pro bono, which means I don't charge the family or the victims anything. If it's the right case. And essentially what you do is you communicate with the prosecutor, and you try to make sure that they're on board and that they've got everything that they need from you and from the victim's family. And then there's you also communicate with the court, and you make statements. And sometimes MARSY'S law representation can be very vigorous, and most of the time it's like when Dave said, when things are working right, you shouldn't need to do much other than just explain the process to the family and kind of hold their hand as you go through it and be there in court on the critical days. But sometimes it gets so messy that you actually have to fight. And on that roadshow case out of Newport again, what we did on that is the elected DA of Orange County, incredibly, tried to dismiss the entire case. So like flat out dismiss a multi-victim rape case of a group of women that don't know each other, which was, I've never seen anything like it. So I fought it, and I fought it on behalf of my clients, and the court actually agreed with me and refused to dismiss it. Then I brought a motion to kick the entire DA's office off the case and get the attorney general appointed, and the court granted that. I think that's the first time it's happened in California history. So MARSY'S law representation most of the time is literally you're kind of a handholder where you're trying, and I'm not demeaning that at all. It's critically important for these people, especially when they've gone through trauma, to have people on their side, which is what's so awesome about this as a group, which is why Dave and I agreed to do it, because we support what you do so much. But they need somebody that is that can explain the process and walk them through. And I know I'm preaching to the choir when I talk about how important that is for victims of violent crime. But sometimes it requires fighting, and those are big fights. And if you get and Dave's right, it's a different role than the civil attorney. It's a different role than the prosecutor. But it's also important to remember it can be a civil attorney that's also suing. Can also appear MARSY'S law. Like Dave does a bunch of MARSY'S law representation on cases, or sometimes he's got cases that I'm going to probably wind up going in on in a MARSY'S law capacity to represent Dave's clients with the DA. And I can talk to DAs and I can talk to judges, because that's what I do all the time. And especially if it's in Southern California, I probably know the DA and I can kind of walk them through what they need, and then I can go back to the family, and I can even provide trial advice since I've done so many if they're willing to listen. Sometimes they are, sometimes their ego prevents that. Sometimes I'm probably just flat out wrong, but it's a different role, and it's a new cog in this system because it's a relatively new law.
We do have a question that's pretty timely. How do statutes of limitations affect MARSY'S law rights?
Well, and I'm going to let Dave talk about the actual statute of limitations, but essentially, if you're a crime victim, there is no expiration date on that. If you are the definition of a crime victim includes not only the person that suffered the abuse, but also their immediate family. And it never washes out. If you're like, for example, somebody might be outside the statute of a molest case or a rape case, but if they're being interviewed as what's called in California an 1109 or an 1108 witness, which is previous abuse that can be introduced in the trial, they're still a crime victim. And so there is no statutory washout period. They still are entitled to all the same rights and dignity and all the rest of that as if it happened yesterday. And fortunately, most judges are very, in my experience, have been very open to that. And so those victim protections don't go away.
You saw my slide on statute of limitations. It said, it was in quotes, it said, this could be anyone giving this advice. Just wait until the criminal case is over and then consult a plaintiff attorney. Okay, that is the worst advice anyone can give. And I'm going to tell you why, because now let's understand what we're talking about. You know, the victim has gone to the police. The DA has filed criminal charges. There's a criminal case pending, and somebody, it could be the DA, it could be the detective, it could be it could be a victim advocate, it could be just a friend of the family and say, hey, look, don't go talk to a civil attorney and don't file anything until this criminal case is over. Well, guess what? You could be basically forfeiting that victim's right to bring a civil lawsuit with that advice, because in the civil side of things, there are very short statutes of limitations sometimes. So let's say it's an adult who is sexually assaulted. And for whatever reason, she has a civil case against the perpetrator's employer. You know, she's sexually assaulted by someone she works with, and that person was hired with a prior felony conviction. Okay, just so she has a right to sue the employer. Well, guess what? If she's told, hey, just let the criminal case run the path, let it run its course, and then bring a lawsuit. In California, for example, you only have 2 years to file a lawsuit. I've had adult victims come to me and they said, hey, the DA or the police or whoever, they said just wait. And I did. And so I waited, and now I'm here in front of you, and you know, and I'm like, well, when did this assault happen? Oh, like 3.5 years ago. They're done. They have forfeited their civil case. And that's really can be devastating to sit there and go, you're out of luck. They gave you bad advice and there's nothing you can do about that. So just, you never want to give that advice. The advice you want to give is, hey, there could be some real short time frames for filing a civil lawsuit. You should talk to a lawyer and make sure you understand what those are. And again, a smart lawyer will, you know, if you're up against the statute, Matt gave you that example of the case we had here, it's got to be filed. Well, the lawyer can still file the lawsuit and then put a hold on it. So the lawsuit can be filed, boom, no statute of limitations issues anymore. And then you just put a hold on that till the criminal case ends. And so again, it's really, really important to not mislead the victim into forfeiting a civil case because you told them, hey, wait however long it takes till the criminal case is over. Matt, is anything you want to add to that?
Well, just that if it's a government agency under 910 of the Tort Claims Act in California, that statute is even 6 months. So it's like everything Dave said is right, and DAs oftentimes don't even know. They're professional criminal attorney. The last thing on their mind is civil statutes and when that can go. Most of them don't even know. But again, a really good DA understands that if there is a potential for compensation, if it's Uber, if it's some sort of business that is somehow enabling this person to do it, your victim is in the incredibly rare position of actually being able to recover. And as you know, for this group, victim witness, you guys know very well that the vast majority, 98% of cases, there probably isn't anybody to recover from. And in those few cases that there are, the recovery can be substantial and can be life-changing. And you know, in the case that Dave and I had, group of 10-year-old boys being molested by a teacher, and we're going to talk about, I mean, that was what Dave was able to do on that. It was kind of the perfect alley-oop. I got the criminal conviction, and that case was a fight. And then Dave went and got financial security for these boys that had, given what had happened to them, was something that it was the best possible outcome. And a DA who's good should have that in their minds all along. But a lot of times they just don't understand how it works.
Yeah, let me add too. Now, look, for children who are victims of abuse, you know, many states have very long statute of limitations. So it's not as big a concern there, but still some states have relatively short ones, and they can be very complicated. So, but particularly if you're dealing with an adult who's been sexually assaulted, that's where it really comes into play. So just be aware of that. And then one other issue, Matt and I want to cover before we get to the case we've been talking to you about, and that is the media, our favorite, right? Everyone's favorite. So let's say you're dealing with, you know, the parents of an abuse victim or the victim himself, herself, and they're really worried, like, hey, is this going to get out in the media, whether it's criminal or civil? And is that a good thing or a bad thing? Or am I going to be exposed? And is my identity going to be out there? I'll let Matt run with this from his perspective first.
Yeah, so here's one of the kind of the good news on this is that, you know, whenever you have a teacher, when you have people, you know, a lot of these tend to be high profile cases for whatever reason. In my experience, the vast majority of the time, the reporters that are involved really want to do right by the victims, and they have their own ethical standards. And again, another example, Todd Spitzer on that Robichaux case actually released a search warrant when he was running for district attorney of Orange County, where he did such a sloppy job redacting it, he released the name of one of the victims. It is massively offensive. Can't believe he did it. He did it to a bank of reporters, and every single reporter had the professionalism not to print it, which is like, it should never come to that, where we have to rely on the reporters' ethics. And I mean, and it's beyond just ethics. It's like, they were human beings about it, and this woman's name didn't need to be out there. And so my experience actually has been very positive with dealing with media, because they've been so professional. Good reporters really they don't want to do any harm. They don't want to, you know, it's different than TV where it's like, here's your name, you know, here's your face. It's most of them, the vast majority are going to want to do it right. Now, there are certainly exceptions to that. And I think that fundamentally dealing with the media, again, the key thing is making sure that that the lawyers are making all those decisions, and that the lawyers hopefully are working together, because a good civil lawyer knows you never have a press conference unless the DA is on board with it, and you shouldn't have a press conference anyway. And I had another case. Sorry for all the war stories. I had a case once with a woman who was one of these. It was a 13-year-old boy. She was a cheerleading coach, married to a professional motocross rider. It was right when I first got to sexual assault, and she denied it, and the boy denied it, and his big brother really wanted, he was outraged at what had happened, and he was 13 and she was whatever. So her attorney went and had a press conference thinking that the information that got it to the police came from the boy, and it didn't. And he took to the airwaves going, he's a liar, that kid's a liar, da da da. And the big brother went in and said, look, come in here and watch this. Look at what he's saying about you. You want to tell the police the truth now? And he did, and I was able to prosecute her because of that. So it's like a bad lawyer plus media equals, you know, it's a nightmare. So good lawyers working together, you can get through it. I hope that answers the question.
It does. You know, I have the same experience with Matt. The beyond the vast majority of reporters out there are incredibly professional, in my opinion, when it comes to protecting the identity of the victim. I've never had a situation that I can think of where anyone exposed a victim's name. They always, you know, keep the victim confidential. And I think you can reassure a victim like, hey, your name's never going to get out there unless you want it out there. I've had adults who absolutely want their name out there as a victim. I see that more and more and more. They embrace it, and it empowers them. But in the civil lawsuit, I mean, sure, the prosecutor will definitely keep the victim's identity private from the public and the media, and same thing in a civil case. Almost all of my cases, there's a caption to every case, right? There's the name of the case, and it can be Jane Doe or John Doe versus whatever school district or whatever it is. So they can be confidentially named. They can be anonymous in all the filings that go to the courthouse, and they don't have to put their name on any documents that are actually filed in the courthouse, which is great. And so that's another way to protect these victims and assure them, hey, coming forward doesn't mean the whole world's going to know you're a victim unless you want the whole world to know. And that's fine, but that's something you talk about with the lawyers first before you do that, because there's a lot of repercussions to doing that, as well as the timing of doing that. One other thing I wanted to say about the media is that the media can be incredibly helpful to victims. Because, real quick example in the news right now, anyone who follows sports or football, there's this quarterback in the NFL, his name's Deshaun Watson. I mean, very, very high profile athlete. And he had a massage therapist come out and say, you know, he sexually assaulted me during a massage. And she went straight to a civil lawyer who apparently tried to negotiate a settlement with Deshaun Watson, and Watson said, no, I'm not settling the case. And the civil lawyer then, went public, had a press conference, and lo and behold, you had 20 other women come forward who said he did the same thing to me. And these women did not know each other. They do not know, they're from different areas and all that. They had no way of knowing each other. And so it can be powerful, because one woman taking on a powerful person like Deshaun Watson, that's tough. 20 women, that's a different story. So let's get to maybe spend 5 minutes on this case that Matt and I worked together on, and then that'll save us maybe 10 minutes or so to answer a lot of your questions. So I'll let Matt talk about this case, and the name is the perpetrator is Jason Abiyankar, and then you can see the civil district was against a school district because Abiyankar was a teacher. But I'll give Matt's. Oh, and let me just show this. So that's a picture of Abiyankar, the teacher. This was a while ago, but it's still pertinent today. Happens all the time, unfortunately. And then, the headlines. But I'll let Matt talk about his perspective of it, and then I'll jump in with my perspective, and you'll see how the interplay plays out in real life.
So this guy was he had a master's. He had a job teaching 10-year-olds at a elementary school in Huntington Beach. And what happened was essentially he would pick a favorite and he would groom these kids, and like you guys have seen a million times, he would pick vulnerable kids, either kids that were going through divorces sometimes, or one kid, his mom had cancer and his dad had left the house, and it's like a predatory thing. And he was working for Huntington Beach, and he was doing a lot of weird stuff, and parents started seeing him alone with kids in the car at lunchtime, and he would lock his door of the classroom and be in there with kids against protocol. People started complaining, but he was also super popular among a bunch of the parents who defended him. And it went back and forth for about a year. And there was a point, finally, the Village View Elementary School, the principal said, you know what, we can't renew your contract next year. You're still on probation. we're not going to take you back. And he threatened to sue them, like classic arrogant, like sex offender, right? Like serial sex, like, and we know a lot of these guys, forgive the term, but are just kind of weenies. But some of them are predatory and arrogant as hell. And he was one of those. And he said, look, I think that you've ruined my reputation by not renewing my contract. I'm going to sue the school unless you write me a glowing letter of recommendation. And that was literally the way he put it, glowing letter of recommendation. So, and they weren't renewing the contract because of all this weird stuff. You've seen massaging a kid during an assembly in the dark. He'd been alone, like they'd seen him in the car, like all this weird stuff, tons of smoke, but no real fire yet, right? And so they did. They wrote him a glowing letter of recommendation. He went to a place called Portola Hills Elementary School in South Orange County, and the letter was so glowing, the principal even called the principal of Village View and said, this guy looks like he's too good to be true. Well, no sooner is the ink dry on that he gets the job, the new semester starts, and he went off the rails and he molested, we think about five more kids down there. So the police then, we had great detectives. They said, okay, nobody knows about the allegations in Portola Hills. And this is like, I hate to say it, this is so long ago, it's almost before, it's before the internet pretty much, or before anybody was on it all the time. And so they went back and they competently went to the class pet from the year before. This kid that Dave wound up representing, who was a great kid with actually nice parents. And sure enough, he explained how he had been orally copulated in the classroom. And that's what was happening. Is this guy was orally copulating 10-year-old boys, among other things. And then they went to the class pet from the year before in Huntington Beach. And this kid the mom was like super active in PTA. He was the one that didn't fit the profile so much because he had very involved parents. And she said, yeah, this is all not true. This guy's wonderful. You want to talk to my kid? I'll go get him right now. Brings him in, sits him down. And the term he used was, yeah, he was sexually harassing me. And what he was doing was orally copulating. So it was, kind of that. So the facts were horrific, but this was one of those cases where if you get the right lawyer, these kids could actually get compensated and get college funds and houses. So Dave, that was when I met him. He came in very low key, and I dealt with a million guys that, a million plaintiffs lawyers up to this point. Dave is far and away the best I'd ever encountered on that. And he was so professional and liked him so much that as a prosecutor, I'm like, hey, families, you want to rally around this guy because he knows what he's doing. He's already involved in the case, totally gets it. He's doing everything right. And that's basically how Dave and I hooked up originally over 20 years ago. Now we're doing them together, which is awesome. But so that one wound up being one of those cases where the court allowed the defense to do these depositions, which got out of hand. But then that allowed me to use that against, to actually prove the case even greater, because it's like when this one kid was up on the stand, it's like, and the lawyers, there was lawyers for the school, for the principal, for him, there was like this gang of civil attorneys in the back. And I actually got in a little trouble with the Court of Appeal because I referred to them as these civil goons in the back. Do they ask you these questions? And the Court of Appeal didn't like that. It was denigrating the legal profession, but every once in a while, I guess it needs to be denigrated a bit. Didn't get reversed, but I got in trouble. But it's because I was so mad at what they'd done, and the jury was even madder than I was, and so was the judge, because we were able to kind of, and I opposed the depositions, and the kids did a great job. And then Dave went and took the baton from me, and we get this, it's a really hard fought, brutal trial that went on, that took a long time. I had great detectives, and we were able to get a conviction on the guy, and he went to prison for 24 years. And then Dave took over and got an awesome settlement because we got again, going back to collateral estoppel, though there will be no test at the end, but collateral estoppel meant we convicted them, they lost. And then the only question for damages with, I believe back then it was $1 million indemnity per kid, was how much is it worth? And so Dave was able to, that's life-changing money for those boys, and the families were to set up, it's enough to get them through college and a down payment on a home. And it really was a life-changing thing for them. And so that's an example of how things can work right. And you have the right people. Dave was the right guy. And we had a good judge, and it all came together.
I would just add this on that case is that, you think that's, oh, there's no way that that scenario happens a lot. What school district would do that? Well, it happens a lot. It's called, they actually have a name for it. It's called passing the trash. Passing the trash. It's when one school district knows they have a really, really, really problematic employee who's doing very suspicious things with kids, and they just want to get rid of the person, and they don't want to get a lawsuit. They don't want the person, they don't want to have to notify all the parents that they're suspicious of this person, and they just want the guy gone. And the guy's like, I'm not going. And it's called passing the trash. They cut a deal and they say, hey, look, you go away quietly. We'll make it easy for you to go away. You can resign. We write you this great letter of recommendation. You could get hired elsewhere. Goodbye. And I'm telling you, I've seen it happen so many times in cases over the years. It's outrageous, and yet it happens. And so again, look, this is a case, a perfect example where you had the prosecutor, Matt, who, you saw the headline, the guy got 24 years in prison. I mean, that's phenomenal. He's never going to harm another kid again in his lifetime. And yet Matt also realized these boys deserve compensation against the school, and also that the school shouldn't be allowed to get away with this. Matt recognized it early on to say, hey, something's really suspicious here. He could have just said, that's not my problem, but he didn't. He preserved the civil case. And I'll tell you, the end game of all this was, sure, the guy's in prison for a long time. Unbelievable. I love that. And also the school district changed their policies. That'll never happen again at that school district. There is no way. I mean, a lot of kids have probably been protected because the school changed their policies, because the prosecutor did the right thing and recognized that there's more to justice here than just putting the guy in prison. So look, we're actually, timing's perfect to take some questions. Let me just run through a couple of slides and then we'll do questions. You've heard it all day. The ultimate goal here, you as victim advocates, or if you're in law enforcement or the courts, whatever, everyone wants to obtain a conviction. And we also want to preserve the victim's civil case if they have one, or at least give them the right to preserve it or not. And you've heard that, a successful partnership between the prosecutor's office and the plaintiff's attorney can really empower the victim. I mean, these victims get so empowered when they see the perpetrator go to prison, and then they see change brought about in schools or youth organizations or things like that. It's really powerful. So we're going to take some questions. Again, here's our emails. Again, don't email your questions to the email. That's for down the road. But Renee's going to hop in here and ask some of your questions of us.
Yep, and you have quite a few. One of the biggest ones, and this is coming up several times in the questions, is a lot of times victims don't have the ability to pay. So what do you suggest people who can't afford a civil attorney do?
Every civil attorney I know that does this works on contingency fee. The victims never pay a penny out of their pocket, even if the case is lost. It's all contingency fee, meaning a percentage of the settlement is how the attorney gets paid. And they don't get paid until the case settles years later. And usually the judge is involved. If it's a minor, the judge is the one who actually sets the contingency fee. So the minor's protected and all that. So payment should never, ever, ever be an issue. And if there's some lawyer out there says, oh, I need to get paid, run.
Yeah. And as far as MARSY'S law goes, especially when there is a concurrent civil case like that, any MARSY'S law lawyer worth their salt would basically do the same thing. They're not going to, like I said, almost all my MARSY'S work is free. It's pro bono. But if there's on a civil case, when there's one that's pending, and there's somebody that's going to have to pay out at the end, that's an easy solution. So literally, these people that think they don't have access to that have the opportunity to get a couple of really good lawyers fighting for them right away, because of the contingency thing that Dave was talking about.
Thanks, guys. So lots of questions on what happens at the end of a criminal case. What if it pleads out? What if the criminal case is not successful? What if a case never makes it to criminal court? How does that impact the civil case?
So if it pleads out, there's two different ways that a plea can be taken. There's a thing called a nolo contendere plea, which means there is no collateral estoppel. But if it pleads out and the person pleads guilty to whatever deal, it's collateral estoppel hits and they automatically win the civil suit. So there is, on a case where it's unsuccessful, all that means is that in the civil case, now they can prove, they can still pursue it because the burden of proof is lower. So the law says, well, the case didn't rise to beyond reasonable doubt, but it may still be beyond a preponderance. And there's a very famous case that we all know about where that's exactly what happened. And that was the O.J. Simpson case, right? O.J. was acquitted of that, but a very competent plaintiff's lawyer came in on behalf of the family and sued. And on the never-ending drama of that case, I actually know Ron Goldman, I'm sorry, the Mr. Goldman and his sister, I know his family. And they, by doing that, they got a civil judgment. And that civil judgment is why OJ wound up trying to hide his assets, which is what brought him to that hotel room in Vegas, which is what led to him going to prison. So it's like, it all kind of fit back in. And there was, in a weird way, there was a bit of justice at the end of that because of the civil case and because you're not stopped from pursuing your civil remedies, even if the criminal case winds up with a not guilty. Hopefully that helps.
We're getting lots of requests in the chat. Dave, can you put the email addresses back up again?
Oh, sure.
Screen.
Here you go.
So also a lot of questions on timing. Do you suggest doing the criminal and civil in tandem? How does the civil case and being able to interview witnesses affect the criminal case? And how does that all play within family courts? Would you recommend getting a divorce first, going through? There are prosecutors who are apparently telling people to wait until family law proceedings are over to pursue cases.
So let me look. I think the best policy, there's always exceptions to this, but if in a perfect world, you want to wait out, you want the criminal case to go forward until completion before you file a civil lawsuit, okay? But that doesn't mean you wait that long to hire the civil lawyer. You keep the civil lawyer in the background the whole time. But in a perfect world, you let the criminal case run its course, you get a conviction, the DA gets a conviction, and then the civil case gets filed. So it can be a nightmare if they're both running in tandem. It can be a nightmare. It can get really ugly. So you really, again, from my perspective, I can get really frustrated because criminal cases can take a while. And so I'm sitting here for a year, 2 years saying, just be patient. We can't file the case until the criminal case is over, and victims get frustrated, but they understand the importance of it.
Okay, in the last minute, I'm going to give you a tough one. There was a civil case that took place decades ago involving a high school music teacher who sexually assaulted numerous students on campus. It appears that nobody wants to take the civil case because of the notice requirements and an issue of negligent supervision, and those components aren't very strong. However, this person believes the teacher is continuing to sexually assault students between ages 14 to 20. As both a civil attorney and a prosecutor, how would you suggest proceeding?
So as I understand that there's no criminal case, I'm surprised there's not a civil lawyer out there who would pursue that. And look, I guess the thing is, if the victim has gone, if the police say insufficient evidence, sorry, we can't criminally charge the person, and then you've gone to 5 lawyers and they all say, I can't take on the case. I don't know, maybe that tells you something about doesn't mean it didn't happen. It just means what can be proven in a court of law, which unfortunately is how lawyers have to guide themselves sometimes. I mean, that's a tough question. I need to know more facts about that. But Matt, you want to weigh in on that?
Yeah, it's if it sounds like I'm a little confused if there was a civil suit way back when, or if it was just it's a current civil suit for something that happened way back when. I saw the written form of that question, but I didn't quite understand that. If there was a civil suit way back when and it was adjudicated, then there's probably not much that can be done now. But again, that would depend on age of the person, age of the victim, how long ago it was, what the statute was. back then. There's been some great progress, like Dave was saying, regarding statute of limitations in children. In California, just in the last couple of years, there's been some very important laws that have been passed recently that essentially preserve a child's right. So if you're a child then, and pursuing it now, it may not be impossible, especially if somebody went and consulted with lawyers before the law had changed, maybe. I would need more information.
I don't see that we're getting it, and we are out of time. So I would like to thank everybody for joining us, especially Dave and Matt, and for the great conversation. I will say that I noted there are several questions about finding attorneys in your states. You can always go to victimbar.org. There is a referral page that we will try to refer cases to attorneys. We can't always, but we will try. And we will be providing these slides and the information from the recordings to you directly. So thanks everyone for joining us.
All right, thank you.
Thanks for having us.